Do you know how the states and territories of India were listed at the time of the adoption of the Constitution in 1950? We're about to embark on a journey through the Indian Constitution, specifically Schedule 1. This schedule is a comprehensive list of India's states and territories, along with their respective territorial jurisdictions, as they were in 1950. It's divided into 4 parts: Part A, Part B, Part C, and Part D. Now, let's delve deeper into how these territories were defined and how they have changed over time. Let's begin with Part A of the schedule, which lists the states of India. At the dawn of India's constitutional adoption in 1950, Part A of Schedule 1 enumerated the states of India. Each state, unique and vibrant in its own right, formed the backbone of the nation. However, like the shifting sands of time, the political landscape of India has been far from static. Over the years, changes and reorganizations have taken place, reshaping the map of India as we see today. Whether through constitutional amendments or other legislative processes, the evolution has been continuous. The creation of new states, the merging of others, or the redefining of territorial jurisdictions all have played their part in this dynamic process. The states we see today are the results of this ongoing evolution. These were the states of India as listed in Part A of Schedule 1, but what about the other parts? Moving on, let us explore the territories listed in Parts B, C, and D of Schedule 1. Part B of the schedule was once home to the territories known as the Chief Commissioner's provinces. These included places like Delhi, Ajmer, and Coorg. But don't go looking for Part B in your constitution today. It was abolished in 1956. Its territories either merged with adjoining states or redesignated as union territories. Next, we have Part C, which represented the Part B states. These were territories governed by a Raj Pramukh, or an appointed chief. Some of these were Travancore Cochin, Vindhya Pradesh, and Bhopal. Similar to Part B, Part C doesn't exist anymore in the constitution. These states were reorganized or merged into existing ones, as India aimed for administrative efficiency. Finally, Part D, the last part of Schedule 1, is pretty straightforward. It lists the territories of the Andaman and Nicobar Islands. Known for their pristine beaches and diverse wildlife, these islands remain a union territory of India today. It's fascinating to see how these territories have evolved over time, not just geographically, but politically and administratively too. The process of reorganization and the creation of new states and union territories has been a testament to India's dynamic nature, always striving for progress and better governance. So, these were the territories of India as they stood in 1950. But what about today? Fast forward to today, let's take a look at how the map of India has evolved. The original states and territories outlined in Schedule 1 of the Indian Constitution have undergone significant transformations. The list, as it stood at the time of the adoption of the Constitution in 1950, has been reshaped and expanded. Today, India is divided into 28 states and 8 union territories, including the National Capital Territory of Delhi. Some of these changes were spurred by linguistic and cultural diversities, while others were catalyzed by geopolitical considerations. Over the years, constitutional amendments and legislative processes have played a crucial role in the reorganization of states and territories. Through these, the Indian government has strived to maintain a balance between cultural identity and administrative efficiency. For instance, the States Reorganization Act of 1956 led to a major overhaul, where states were reorganized on a linguistic basis. More recently, in 2019, Jammu and Kashmir, originally a state, was reconstituted into 2 separate union territories, Jammu and Kashmir and Ladakh. This was done to ensure better governance and to address long-standing socio-political issues. These changes reflect the dynamic nature of India's political landscape and its commitment to adapt and evolve in response to the needs and aspirations of its people. And that's how the states and territories of India have evolved from the time of the adoption of the Constitution to the present day. So that was a journey from 1950 to 2024, exploring the states and territories of India. We've seen how the original Schedule 1 of the Indian Constitution has evolved over time, with changes in the states and territories due to reorganization, creation of new states, and constitutional amendments. From the parts A, B, C, and D to the present scenario, India's territorial tapestry continues to be woven. We hope this journey has given you a deeper understanding of the evolution of the Indian states and territories. Thank you for joining us on this enlightening journey. Do you know how the salaries and allowances of various constitutional functionaries in India are determined? Welcome to our exploration of Schedule 2 of the Indian Constitution, a pivotal guide that sets the financial terms for some of the nation's highest offices. This includes the President of India, the governors of states, the judges of the Supreme Court and High Courts, and the Comptroller and Auditor General of India. Schedule 2 is not just about numbers and figures, it's about maintaining the independence and integrity of these critical roles. By ensuring these offices are adequately compensated, we safeguard them from being swayed by financial considerations. But what happens when changes need to be made to these provisions? Well, any alterations can only be enacted by the Parliament through legislation. This democratic process reinforces the principles of separation of powers and checks and balances within the Indian constitutional framework. Now let's dive deeper into the specifics of Schedule 2. Starting at the top, we have the President of India. As the nation's highest constitutional authority, the President's salary and benefits are meticulously outlined in Schedule 2 of the Indian Constitution. But how are these emoluments determined? The President's salary is not arbitrary. Rather, it is a reflection of the magnitude of the responsibilities that come with holding the office. This ensures the incumbent is not swayed by financial considerations, thereby preserving the integrity of the presidency. The allowances and benefits too are not just random perks. They serve a purpose: to enable the president to discharge his or her duties effectively. These may include everything from maintenance for official residences to travel expenses, and more. Importantly, any alterations to these provisions can only be made by the Parliament through legislation, reinforcing the democratic ethos of our nation. The President's salary and allowances are designed to reflect the dignity and importance of the office. Moving on to other significant constitutional functionaries, let's dive deeper into Schedule 2 of the Indian Constitution. This section outlines the emoluments and benefits of the governors of states, judges of the Supreme Court and High Courts, and the Comptroller and Auditor General of India. Firstly, the governors of states. These individuals play a pivotal role in India's federal structure, and their financial compensation is set to reflect this vital responsibility. Their salaries are determined by the President and can only be altered via legislation by the Parliament, ensuring a democratic process is followed. Next, we have the judges of the Supreme Court and High Courts. Their salaries are of paramount importance in maintaining the independence of the judiciary. The Constitution meticulously outlines their emoluments, ensuring that judges can carry out their duties without any financial worries. Again, any alterations to these provisions require legislation by the Parliament, upholding the principles of separation of powers and checks and balances. Lastly, let's discuss the Comptroller and Auditor General of India. This office is responsible for auditing all receipts and expenditure of the Government of India and the state governments, including those of bodies and authorities substantially financed by the government. It's a role of immense significance, and the compensation is set accordingly to ensure the office holder can perform their duties without being swayed by financial considerations. The primary purpose behind these provisions is to ensure that these functionaries are adequately compensated for their services. It's about more than just remuneration. It's about maintaining the integrity and independence of these offices. By providing a decent salary and allowances, the Constitution ensures that these functionaries can serve the nation without being unduly influenced by financial considerations. In conclusion, the salaries and allowances outlined in Schedule 2 are not just figures on a page. They are a testament to the value we place on our constitutional functionaries and the roles they play in upholding our democratic system. These provisions ensure that these functionaries are adequately compensated and not unduly influenced by financial considerations. To summarize what we've discussed so far, Schedule 2 of the Indian Constitution plays a pivotal role in preserving the independence and integrity of various constitutional offices. It lays out the emoluments and benefits for the President of India, the governors of states, the judges of the Supreme Court and High Courts, and the Comptroller and Auditor General of India. This schedule ensures that these office holders are adequately compensated for their services, protecting them from any undue financial influence. It's crucial to remember that any modifications to Schedule 2 can only be made by the Parliament through legislation. This safeguard embodies the democratic process and upholds the principles of separation of powers and checks and balances within the Indian constitutional framework. So, whether it's the President at the helm or a judge in the Supreme Court, Schedule 2 is there to ensure fairness and independence. And there you have it, a comprehensive look at how the salaries and allowances of various constitutional functionaries in India. Do you know what Schedule 3 of the Indian Constitution is? No? Well, let's dive right in. Schedule 3 holds a significant place in the Constitution of India. It contains the forms of oaths or affirmations for various constitutional positions. These are not mere words but solemn promises that individuals make when they step into their respective offices. From the President of India down to the members of both Houses of Parliament, each one takes an oath or makes an affirmation. Similarly, the Vice President, the Governor of a state, ministers in the Union government, as well as those in the state government, and members of the State Legislative Assembly and the Legislative Council also make these pledges. These oaths or affirmations symbolize their commitment to uphold the Constitution and discharge the duties of their respective offices faithfully. Now that you have an overview, let's delve into the specifics of each oath. Starting from the top, the first 3 oaths in Schedule 3 are for the President, Vice President, and the Governor. The President of India, as the head of state, takes an oath to faithfully execute the office, to preserve, protect, and defend the Constitution and the law, and to devote himself or herself to the service and well-being of the people of India. The Vice President, who doubles as the ex officio chairman of the Rajya Sabha, takes a similar oath, underscoring the commitment to uphold the Constitution, serve the people, and discharge the duties of the office. Lastly, the Governor of a state in India, who acts as the representative of the President in the state, swears an oath of allegiance to the Constitution, vowing to preserve, protect, and defend it. These positions, being the highest in the land, carry a great deal of responsibility reflected in their oaths. Moving on, we have the oaths for the ministers and members of Parliament. These oaths or affirmations are not merely ceremonial, they are solemn promises that hold great significance in the democratic fabric of India. Let's start with the Minister for the Union, who is a part of the central government. Upon assuming office, they take an oath to bear true faith and allegiance to the Constitution of India, to uphold its sovereignty and integrity, and to faithfully and conscientiously discharge their duties as a minister. Similarly, a minister for a state, who is part of the state government, takes an oath with the same words, pledging allegiance to the Constitution, upholding its sovereignty and integrity, and promising to faithfully execute their responsibilities. Then, we have the members of Parliament, individuals elected to represent the people in the 2 houses of Parliament, the Lok Sabha, also known as the House of the People, and the Rajya Sabha, or the Council of States. Upon assuming their roles, they too swear an oath to bear true faith and allegiance to the Constitution of India, to uphold its sovereignty and integrity, and to faithfully discharge the duty upon which they are about to enter. As you can see, these oaths are a solemn promise to serve the country and its people faithfully. Lastly, we have the oath for members of the state legislature. This solemn pledge is taken by members of the State Legislative Assembly and the Legislative Council where it exists. The significance of this oath is truly paramount. It serves as a beacon, guiding these individuals in their duty to maintain the integrity of the state government. They commit to uphold the Constitution, adhere to its principles, and discharge their duties diligently. This oath, like the others, signifies a pledge to uphold the Constitution and perform their duties diligently. So that's a run-through of the various oaths and affirmations in Schedule 3 of the Indian Constitution. From the President to the Vice President, from the Governor to the Union and State Ministers, and from members of Parliament to members of the State Legislature, each role has a unique oath to affirm. These oaths are more than mere formalities. They signify the commitment of these individuals to uphold the Constitution and faithfully discharge their duties. They embody the spirit of service to the Indian people and the pledge to defend the democratic ideals of the world's largest democracy. They are a solemn promise, a vow to put the welfare of the nation above all else. As we've seen, each oath carries its own weight and significance, echoing the responsibilities that come with these positions of power and influence. Remember, these oaths are not just words, but a solemn promise to serve and protect the world's largest democracy. Imagine a house that never dissolves, a house that represents the diverse states and union territories of India. This is the Rajya Sabha, an integral pillar of the Indian Constitution. Unlike its counterpart, the Lok Sabha, which dissolves every 5 years, the Rajya Sabha stands as a permanent body, ensuring continuous legislative proceedings. It's a house that echoes the voices of India's states and union territories, giving them a platform on the national stage. The Rajya Sabha doesn't merely represent the people, it represents the regions and their unique identities. It's not just about the numbers. Each state, each union territory, regardless of its size or population, has a voice. It's a testament to India's rich diversity and the strength of its federal structure. And so, the Rajya Sabha stands, a house that never sleeps, ceaselessly working for the people of India. The Rajya Sabha is the voice of India's regions, a testament to the country's diversity and federal structure. But how does the Rajya Sabha ensure fair representation? The answer lies in Schedule 4 of the Indian Constitution. This section of the Constitution is like a blueprint, a guide that meticulously details how seats in the Rajya Sabha are allocated. It's the master plan that ensures each state and union territory in India has a voice in this crucial legislative body. At its core, Schedule 4 is about fairness. It's about ensuring every state, every union territory, regardless of size or population, has a say in the decisions that shape the nation. The allocation of seats in the Rajya Sabha is largely based on population. The more populous a state, the more seats it gets. The latest census data is used to determine this, but it's not just about the numbers. The President of India plays a crucial role here, having the power to specify the number of seats allocated to each state and union territory. But what about the union territories? They're a unique part of India's political landscape. Schedule 4 recognizes this, and it specifies their representation separately. Despite population size, each union territory is allocated a fixed number of seats. This ensures they too have a voice, that they too are heard. And then there's the nomination by the President. This is where Schedule 4 introduces a dash of diversity to the Rajya Sabha. The President can nominate individuals who have made significant contributions to art, literature, science, and social services. These are the voices that bring a different perspective, a fresh viewpoint to the Rajya Sabha. Members of the Rajya Sabha serve for a term of 6 years. However, to maintain continuity, 1/3 of the members retire every 2 years. This system keeps the Rajya Sabha dynamic and ever-evolving, just like the nation it represents. Thus, Schedule 4 ensures that the Rajya Sabha is a vibrant, dynamic, and representative body. It's the guardian of fairness, the custodian of representation, ensuring every corner of India has a voice in the Rajya Sabha. So, what should you remember about the Rajya Sabha and Schedule 4 of the Indian Constitution? Well, it's important to remember that the Rajya Sabha plays a crucial role as a representative body of the states and union territories of India. It's a permanent fixture in India's parliamentary structure, meaning it never dissolves, providing continuity in the legislative process. Now, let's take a quick recap of the key points about Schedule 4. First up, seat allocation. The schedule outlines the distribution of seats in the Rajya Sabha to each state and union territory. This allocation is primarily based on the population of the respective states and territories, according to the most recent census data. The President of India has the authority to specify the number of seats allocated to each state and union territory. Next, we have the representation of union territories. While most of the seats are allocated based on population, the representation of union territories is handled a bit differently. These territories are given a fixed number of seats regardless of their population size. Then there's the matter of presidential nominations. The President of India holds the power to nominate members to the Rajya Sabha. These are typically individuals who have made significant contributions to fields like art, literature, science, and social services, and their inclusion brings a diverse range of expertise and perspectives to the table. Finally, let's not forget the duration of representation. Members of the Rajya Sabha are elected for a term of 6 years. However, 1/3 of the members retire every 2 years. This cycle ensures that there's always a mix of fresh perspectives and experienced hands in the House. And remember, the allocation of seats in the Rajya Sabha is periodically reviewed and updated to reflect changes in population distribution among states and territories. This ensures a fair and equitable representation of all parts of India in the upper house of the parliament. In essence, the Rajya Sabha and Schedule 4 together ensure that India's diversity finds a voice, and that voice is heard loud and clear. Ever wondered how tribal areas are governed in India? Today we're delving into the fascinating topic of Schedule 5 of the Indian Constitution. This key legislation outlines the administration and governance of tribal areas across the country. Grasping its essence not only reveals the intricacies of tribal governance, but also underscores the importance of safeguarding cultural and socio-economic interests of tribal communities. So, without further ado, let's embark on a journey through India, exploring the governance of its tribal areas. First, we venture into the northeast, a region rich in tribal culture and heritage. In the verdant state of Assam, the tribal areas as specified under Schedule 5 of the Indian Constitution are indeed a testament to the rich tapestry of tribal life that thrives here. These areas are governed by special provisions aimed at safeguarding the cultural, social, and economic interests of the tribal populations. Moving on to the picturesque state of Meghalaya, the tribal areas are spread across the Khasi Hills, Jantia Hills, and the Garo Hills districts. Here, the tribal communities are not just a demographic statistic but an integral part of the state's identity. The governance in these regions is tailored to protect and promote the rights and interests of these tribal communities. In the easternmost state of Mizoram, the tribal areas are predominantly found in the Chakma, Lai, and Mara districts. The administration here is marked by a distinct emphasis on the protection of the rights of its tribal populations. Unique laws and regulations are in place to cater to the specific needs of these tribal communities. The Northeast, with its distinct tribal cultures, has unique governance structures in place. These are designed to preserve the tribal heritage and to ensure that the rights and interests of these communities are always upheld and protected. These regions are a shining example of how diversity can be managed and nurtured within the larger framework of a nation's constitution. Moving on, we delve into the tribal heartlands of Tripura and Manipur. Nestled in the lush landscapes of East and Central India, these regions are home to a rich tapestry of tribal communities, each with their unique customs, traditions, and languages. In Tripura, the tribal areas specified in Schedule 5 of the Indian Constitution encompass North Tripura, South Tripura, and Dhalai districts. These areas are teeming with vibrant tribal cultures, and the government has implemented specific laws and regulations to ensure their protection and development. Similarly, in Manipur, the tribal areas are primarily situated in the hilly regions of the state. These areas are known for their distinct tribal cultures that have been preserved through centuries. The government, acknowledging the unique needs of these communities, has enacted laws and regulations tailored to their circumstances. The administrative measures taken in these regions are not merely about governance. They carry the Indian government's commitment to safeguard the cultural, social, and economic interests of the tribal communities. These provisions are a testament to the government's dedication to preserving the tribal heritage and promoting their well-being. In essence, the tribal areas of Tripura and Manipur are not just geographical territories. They are living museums of ancient cultures and traditions, a testament to the diversity of India. They are the focal points of the government's efforts to strike a balance between development and preservation. These regions showcase the Indian government's commitment to preserving tribal heritage and promoting their well-being. Lastly, we explore the tribal regions of Arunachal Pradesh and Nagaland in northern India. Arunachal Pradesh, known as the land of the dawn-lit mountains, is home to a diverse range of tribes. The tribal areas here Specifically, the Tuensang district and the tribal areas districts are governed by unique administrative structures designed to cater to the specific needs of these communities. Similarly, Nagaland, a state known for its rich tribal culture and vibrant festivals, has its tribal areas in the Tuensang district and the tribal areas districts. Unique laws and regulations are in place here, tailored to meet the needs of the tribal communities. These administrative structures and regulations, while unique, serve a common purpose: to safeguard the cultural, social, and economic interests of the tribal populations. The governance of these regions reflects India's commitment to protecting the rights and interests of its tribal populations. Across India, the governance of tribal areas is a complex but essential task. We've journeyed through the tribal areas outlined in Schedule 5, stretching from the hills of Assam to the districts of Nagaland. We've seen governance structures and protections in place, tailored to the unique needs of these communities. This intricate tapestry of administration safeguards tribal culture, social norms, and economic interests. Understanding these diverse governance structures helps appreciate India's efforts in preserving tribal heritage and promoting their welfare. Do you know about the special provisions for tribal areas in the Indian Constitution? Well, tucked away within this robust document is Schedule 6, a distinct part of the Indian Constitution that focuses on the administration of tribal areas in the states of Assam, Meghalaya, Tripura, and Mizoram. These regions are home to tribes with unique social, cultural, and economic characteristics. To preserve these unique identities and promote their development, Schedule 6 was established. It outlines a different way of administering these areas, distinct from the rest of the state. At the heart of Schedule 6 is a commitment to protect and promote the rights and interests of these tribal communities. This includes safeguarding their land, resources, and traditional customs, and ensuring that the laws and policies formulated for these areas are sensitive to their socio-economic conditions and cultural practices. Schedule 6 is a unique feature of the Indian Constitution, designed to protect and empower tribal communities in specific regions. One of the key features of Schedule 6 is the establishment of autonomous district councils. These councils are the heart and voice of tribal areas, a unique administrative structure designed to cater to the distinct social, cultural, and economic characteristics of tribes residing in Assam, Meghalaya, Tripura, and Mizoram. Each autonomous district council, or ADC, is composed of elected members from the tribal communities, along with nominated members. They're not just figureheads, they hold legislative, executive, and financial powers, providing a robust framework for governance in these tribal areas. From land to forests, agriculture to local government and cultural matters, these councils have the authority to make laws on a broad array of subjects within their jurisdiction. They also manage financial resources allocated to them by the state government, with the power to levy taxes, fees, and tolls. These councils play a crucial role in governing tribal areas, ensuring their unique identity and promoting their development. Protection of tribes is a major aspect of Schedule 6. But how is this achieved? The answer lies in the safeguards put in place for tribal land, resources, and traditional customs. Schedule 6 is a shield, a protective layer that keeps the unique cultural tapestry of the tribes intact and their resources secure. It ensures that the laws and policies formulated for these areas are not just a random cut-and-paste job, but they take into account the socio-economic conditions and cultural practices of the tribal population. But who ensures the smooth functioning of these safeguards? Enter the governor. The governor of the state holds special responsibilities regarding tribal areas under the 6th schedule. They have the power to issue regulations for ensuring peace and good governance in these areas. In certain matters, these regulations can even override state laws. The governor's special responsibilities ensure that the rights and interests of tribal communities are upheld. Land and resources are central to tribal communities. So how does Schedule 6 protect them? Well, the 6th schedule of the Indian Constitution is a beacon of hope for these communities, offering robust safeguards for their lands and resources. It acknowledges the intrinsic link between tribal communities and their environment, and the crucial role this connection plays in their socio-cultural fabric. The provisions of Schedule 6 are carefully crafted to shield tribal lands from exploitation. They restrict the transfer of tribal lands to non-tribal individuals or entities. This means that a person or a company outside the tribal community cannot acquire tribal land without adhering to strict legal procedures. This provision acts as a bulwark against land alienation, one of the most pressing issues faced by tribal communities. But it's not just about land. The schedule also protects the resources found on these lands. Forest produce, minerals, and other natural resources that are the lifeblood of these communities are also safeguarded. This ensures that the fruits of the land remain with those who have tended to it for generations, preventing external entities from reaping the benefits at the expense of the tribes. Now, let's talk about empowerment. Schedule 6 doesn't just protect, it empowers. It grants tribal communities autonomy in local governance, allowing them to make decisions that directly impact their lives. Through the establishment of autonomous district councils, tribal communities are given the reins to govern their areas, to make laws on various subjects, and to manage their resources. This autonomy respects their traditional practices and social institutions while integrating them into the democratic framework of the country. In essence, Schedule 6 is more than a legal provision. It's a testament to the constitutional commitment to preserving the unique identity of tribal communities whilst promoting their development. It's a tool for tribal empowerment, a shield for their lands and resources, and a recognition of their invaluable contribution to the country's cultural diversity. Through Schedule 6, the Indian Constitution ensures the protection and empowerment of tribal communities, respecting their unique identity and promoting their development. Do you know how legislative powers are distributed in India? Well, it's through a fascinating system outlined in Schedule 7 of the Indian Constitution. This ingenious system, like a well-orchestrated symphony, ensures a harmonious balance of power between the central and state governments. It's a vital backbone that supports the federal structure of the nation, giving both levels of government their respective areas of authority. But how does this happen? The answer lies in 3 distinct lists: the Union List, the State List, and the Concurrent List. Each of these lists plays a unique role, a bit like the different sections of an orchestra, each contributing to the overall melody, but with a distinct sound of its own. They lay out the subjects on which the Parliament and the state legislatures have the power to legislate, ensuring a clear division of authority and preventing overlapping and conflicts in legislation. Let's dive deeper into each of these lists and see how they help in maintaining the fine balance of power in the country. First up, we have the Union List, also known as List 1. This list is quite special in the grand scheme of things. It contains a series of subjects where the Parliament holds the reins and has the exclusive power to legislate. Now you might be wondering, what kind of subjects are we talking about? Well, the list includes some pretty hefty areas of governance. Consider defense, for instance, or foreign affairs. These are subjects of national importance, requiring a unified approach, and thus they fall under the Union List. Then there's atomic energy, a sector that needs careful and centralized regulation. And let's not forget about banking, currency, and communication, areas that form the backbone of our economy and society. So, in a nutshell, the Union List is all about those subjects where the Parliament takes the lead, ensuring a coherent policy and legal framework for the entire nation. So, that's the Union List, the realm of the Parliament. Next in line is the State List, or List 2. This list is a bit different from the Union List we just discussed, as it outlines the subjects where the state legislature exclusively holds the reins of legislation. What does this mean? Well, in simple terms, it means that the state legislature gets to make the rules on these particular subjects. Now, let's dive into some of these key subjects. They include police matters, public health, and agriculture. We also have local government and land on the list. So, if a state wants to implement a new public health initiative or pass laws regarding local government, it can do so without interference from the Parliament. This autonomy allows each state to address its unique needs and circumstances, providing tailored solutions for their residents. It's a beautiful dance of decentralized governance that still falls within the larger framework of the Indian Constitution. That's the State List for you, where the state legislature holds sway. Finally, we have the concurrent list, also known as List 3. This list plays a unique role in the division of legislative powers. It comprises subjects on which both the parliament and the state legislatures have the authority to legislate. Essentially, it's a collaborative space where both central and state governments can bring their perspectives to the table. But what happens when there's a clash of opinions? Well, in such situations, the union law holds the upper hand. If there is a conflict between union and state laws on the same subject, the union law prevails. Now, what are some of the key subjects on this list? They include criminal law, marriage and divorce, bankruptcy and insolvency, and education. These subjects touch on crucial aspects of our lives, making the concurrent list a vital part of our legislative structure. That's the concurrent list, a shared space of legislative power. So that was a quick tour of legislative power distribution in India. We delved into the union list exclusive to parliament, covering subjects such as defense, foreign affairs and banking. We explored the state list solely for state legislature, including matters like police, public health and agriculture. And we dissected the concurrent list, a shared legislative space, housing topics like criminal law and education. These three lists form the backbone of India's federal structure, delineating authority between central and state governments. They prevent legislative overlap and conflicts by clearly assigning areas of jurisdiction. This setup maintains India's unity while also allowing decentralized governance. It's a testament to the democratic ethos of the country, granting states autonomy in certain matters, yet ensuring a unified approach where necessary. Remember, these lists are not just about power, but about creating a balance for efficient governance. Thank you for tuning in and stay curious. Do you know how many languages are recognized by the Indian Constitution? The number might surprise you. Welcome to a journey into the linguistic diversity of India. In the heart of our Constitution, Schedule 8 rests the recognition of the nation's rich tapestry of languages. This crucial schedule acknowledges the languages that are an integral part of India's cultural and social fabric. Initially, 14 languages were given this honor, etching them into the constitutional framework of our country. But the linguistic landscape of India is ever evolving, just like its people. Over the years, we've seen more languages earn their place in Schedule 8, reflecting the dynamic and inclusive nature of our nation. Each one of these languages carries with it a unique cultural heritage and contributes to the vibrant diversity of India. So let's dive into the linguistic diversity of India, starting with the first language recognized by the Constitution. The Indian Constitution initially recognized 14 languages. Want to know which they were? Let's take a journey through the linguistic landscape of India as we delve into the original 14 languages recognized by the Indian Constitution. First up is Assamese, the primary language of the state of Assam. It's a rich language that plays a big role in the cultural fabric of the region. Next, we have Bengali, predominantly spoken in West Bengal and parts of Assam, Tripura, and Jharkhand. This language is the vehicle of a vibrant literary tradition. Then there's Gujarati, the language of Gujarat, with its unique script and distinctive phonetics. We can't forget Hindi, the official language of India, spoken widely across the country and serving as a unifying linguistic thread. Kannada, the official language of Karnataka, with its ancient origins and beautiful script, is another gem. Kashmiri, primarily spoken in the Kashmir Valley, adds to the linguistic diversity with its unique vocabulary and syntax. Konkani, the official language of Goa, is a beautiful blend of various influences. Moving south, we have Malayalam, the official language of Kerala, known for its complex grammar and rich literary tradition. Manipuri, also known as Meitei, is spoken in Manipur and is a crucial part of the state's cultural identity. Marathi, the official language of Maharashtra, has a rich history and a vibrant contemporary literary scene. Next, we have Nepali, spoken in the hill regions of India, particularly Uttarakhand, Sikkim, and West Bengal. Oriya, now known as Odia, is the official language of Odisha, known for its unique script and phonetics. Punjabi, the official language of Punjab, is a language of rich folk tradition and music. Sanskrit, an ancient language of India, holds great religious and cultural significance and is the root of many modern Indian languages. Finally, there's Urdu, spoken by the Muslim community and recognized as the second official language in some states, known for its poetic expressions. These 14 languages laid the foundation for linguistic diversity in India, but the list didn't stop there. Over time, more languages found their rightful place in the Indian constitution. The Sindhi language, spoken by the Sindhi community, primarily in Gujarat and parts of Rajasthan and Maharashtra, was added by the 21st Amendment Act of 1967. This amendment recognized the cultural significance of Sindhi and its contribution to India's linguistic diversity. Following this, the 71st Amendment Act of 1992 saw the inclusion of 3 more languages: Konkani, the official language of Goa; Manipuri, spoken in Manipur; and Nepali, spoken in the hill regions, particularly in parts of Uttarakhand, Sikkim, and West Bengal. Each of these languages brought with them a rich tapestry of cultural heritage and unique linguistic nuances, further enriching India's linguistic landscape. These additions were a testament to the evolving recognition of India's diverse linguistic heritage. But the constitution had room for more, and in the early 2000s, 4 more languages were added. In 2004, the constitution welcomed Bodo, Dogri, Maithili, and Santali. These languages were inducted through the 92nd Amendment Act of 2003, further enriching India's linguistic diversity. Bodo, a language steeped in the culture of the Bodo people; Dogri, the tongue of the Dogra region; Maithili, a language that breathes life into the cultural essence of Bihar; and Santali, a language of the Santhal tribe, contributes significantly to India's cultural mosaic. And with that, the constitution recognized a total of 22 languages. Recognizing these languages isn't just about acknowledging their existence. It's about embracing the vibrant linguistic diversity that weaves the rich cultural tapestry of India. Each language, with its unique structure and syntax, tells a story of its people, their history, and their traditions. Within our constitutional framework, these languages represent the spirit of unity in diversity, the cornerstone of our national identity. So, next time you hear an Indian language, remember, it's more than just words. It's a piece of India's rich and diverse cultural tapestry. Have you ever wondered about the land reform laws in the Indian Constitution and their impact on social justice and economic development? Well, these laws enshrined in Schedule 9 of the Constitution were designed with a very specific purpose: to bring about agrarian reforms. They aimed to redistribute land from large landowners to landless farmers or tenants, thereby ensuring a fairer distribution of land resources. The goal was not just to promote agricultural productivity, but also to advance social justice. What's notable is that these laws were given a unique protection under the Constitution. Schedule 9 provides them immunity from judicial review, meaning they cannot be challenged in courts for violating fundamental rights. This shield was put in place to ensure that these laws could be effectively implemented, unhindered by legal challenges. Now, you might be wondering about the specifics of these laws and how they have been implemented over time. Let's delve deeper into the chronological order of these laws and their implications. The story of land reforms in India begins with the inception of the Indian Constitution. The Constitution, in its original form, didn't directly address land reforms. However, it empowered the state governments to enact laws to implement agrarian reforms. This was a bold move given the socio-economic landscape of the time. Land ownership was highly skewed, with large tracts of productive land in the hands of a few intermediaries like zamindars or landlords. These intermediaries were often disconnected from the agricultural activities, merely collecting rent from the landless farmers or tenants. The state governments, recognizing the need for a fairer distribution of land resources, began formulating laws to rectify this imbalance. These laws aimed at promoting agricultural productivity, social justice, and economic development in rural areas. The stage was set for a large-scale transformation of the rural agrarian structure. Now that we've covered the inception, let's move on to the key provisions of these laws. The land reform laws encapsulate several key provisions, each designed with a specific purpose. Let's delve into them one by one. First, there's the abolition of intermediaries. This provision was enacted to eliminate the layers of landlords, often known as zamindars, who owned vast expanses of land, but had little to no involvement in the agricultural activities. These intermediaries would collect rent from tenant farmers, reaping the benefits without putting in the sweat and toil. The abolition of intermediaries redirected the profits from the land back to those who worked it, fostering a more equitable system. Next, we have tenancy reforms. These laws were designed to safeguard the rights of tenant farmers, providing them with security of tenure and fair rents. It also put in place measures to protect their rights in case of eviction. This ensured that tenant farmers weren't left at the mercy of landlords and could continue their livelihood without fear of sudden and unjust displacement. The ceiling on land holdings was another significant provision. This law imposed a limit on the maximum amount of agricultural land an individual or family could own. Any surplus land would be redistributed to landless farmers. This provision aimed to prevent the concentration of land resources in the hands of a few and promote a more equitable distribution of land. Land consolidation was another vital measure. This provision aimed to combine fragmented land holdings into larger, more efficient units. It helped to increase agricultural productivity by making farming operations more efficient and reducing the wastage of resources. Finally, there were laws regulating agricultural land use. These regulations were put in place to prevent the diversion of agricultural land for non-agricultural purposes and promote sustainable farming practices. It aimed to ensure that the agricultural land was used responsibly and sustainably, benefiting both the current and future generations. These provisions, while varied, all aim to promote social justice and economic development. They are the pillars of the land reform laws, each serving a unique purpose in transforming the landscape of rural India and empowering its farmers. Land reform laws in India have played a significant role in shaping the nation's agricultural landscape. By abolishing intermediaries, these laws have directly connected farmers with the land, eliminating unnecessary layers that often exploited the agricultural workforce. Tenancy reforms provided security, fair rents and rights to tenant farmers, ensuring their livelihoods weren't at the mercy of landlords. States also set ceilings on landholdings, a move that redistributed land resources more equitably, providing opportunities for landless farmers. Land consolidation and the regulation of agricultural land use have further increased farming efficiency and promoted sustainable practices. Through these measures, enshrined in Schedule 9, land reform laws have advanced the twin goals of social justice and economic development. They've helped to level the playing field, promote productivity, and ensure the sustainable use of land resources. Remember, these laws are not just about land, but about ensuring fairness and progress in one of India's most vital sectors. Have you ever wondered what happens when a legislator defects from his or her party in India? In the vibrant world of politics, such moves can have significant repercussions. But how exactly does the Indian Constitution handle this? Enter Schedule 10, a set of provisions specifically designed to tackle defection. These provisions were not originally part of the Constitution, but were introduced later through the 52nd Amendment Act back in 1985. They provide a clear framework to manage and penalize defections, maintaining stability in the governance and upholding the integrity of political parties. But it's not just about the penalties. These laws also help to reinforce the principles of party discipline, ensuring that legislators remain committed to their respective parties and the ideologies they represent. So what exactly constitutes a defection? Let's delve into that next. Defection, in political terms, is not as simple as changing sides. In the context of the Indian Constitution, specifically Schedule 10, defection carries a specific definition. It refers to a situation where a member of a house who belongs to a particular political party voluntarily gives up the membership of his or her party. This could also mean voting or abstaining from voting in a manner contrary to the direction of his or her party. So, if a representative decides to renounce their party affiliation or chooses to vote in a way that contrasts with their party's directive, they are considered to have defected. It's not merely about switching allegiances. It involves a voluntary and deliberate act of deviating from the party's stand, which can disrupt the party's unity and potentially destabilize the government. However, not all instances of changing party allegiance are considered defection. There are exceptions. There are certain scenarios where switching party allegiance doesn't count as defection. Now, let's delve into these exceptions as stated in Schedule 10 of the Indian Constitution. Firstly, if a member is elected as a presiding officer of a house, such as the Speaker of the Lok Sabha or the Chairman of the Rajya Sabha, and they choose to voluntarily give up the membership of their party, this is not considered defection. This exception is in place to ensure the neutrality of the presiding officer. Secondly, if a member decides to merge his party with another party, this too is not considered defection. This exception is in place to allow for the natural ebb and flow of political alliances. Understanding these exceptions can help us appreciate the nuances of political defection in India. But what happens when no exceptions apply and a member defects? That's where disqualification comes in. If a member of a house is found to have defected, they face disqualification. But what does this process of disqualification entail? Well, it's not as simple as it sounds. Here's how it works. Upon suspicion or evidence of defection, an investigation is initiated. This investigation is not done by just anyone. It's the responsibility of the presiding officer of the house. This could be the speaker in the case of the Lok Sabha or the chairman in the case of the Rajya Sabha. They hold the authority to make the final decision on whether a legislator has indeed defected and should be disqualified from their position. This authority granted to the presiding officer is a testament to the gravity of the situation. Defection isn't taken lightly, and neither is the decision to disqualify a member. Yet, the decision of the presiding officer isn't final. There's room for appeals. So, a member has been disqualified for defection. What's next? Well, this isn't the end of the road. The decision of the presiding officer isn't final and absolute. It can be challenged. The member in question, or any other member who disagrees with the decision, can appeal to the High Court. And if they're still not satisfied, they can take it a step further and appeal to the Supreme Court. Let's quickly recap what we've discussed. Schedule 10 of the Indian Constitution, added by the 52nd Amendment Act of 1985, sets out the provisions for disqualification of legislators on the grounds of defection. It outlines what constitutes defection, the exceptions to it, and the process of disqualification. The presiding officer of the House, be it the Speaker or the Chairman, holds the authority to make this decision. Ultimately, Schedule 10 is a crucial tool to uphold the principles of party discipline and maintain the integrity of political parties in India. Ever pondered how local governance functions in rural India? Today, we dive into Schedule 11 of the Indian Constitution. This schedule, added by the 73rd Amendment Act of 1992, is fundamentally designed to provide for the constitution of panchayats in rural areas. To understand this better, let's define a few key terms. First off, panchayat refers to a local self-government institution at the village level. Gram Sabha is a body consisting of persons registered in the electoral rolls of a village. Panch and Sarpanch are members and chairpersons of these Gram Panchayats respectively. These terms and many more are vital as they provide clarity and uniform interpretation, helping us comprehend the composition, structure and formation of panchayats at different levels. From the Gram Panchayat at the village level to the Zila Parishad at the district level. Understanding these definitions forms the basis for grasping the structure and function of panchayats. Now that we know the key terms, let's discuss the structure and duration of panchayats. These local self-governance bodies have a tiered structure. At the base, we find the Gram Panchayat, which is an assembly of villagers. Moving up a level, we encounter the Panchayat Samiti at the block or taluka level. At the top, presiding over an entire district, is the Zila Parishad. This hierarchical setup ensures that every level of rural life is represented and has a voice. Now, let's talk about duration. Each of these panchayats has a term of 5 years. This means that every half-decade, the villagers have the opportunity to elect new representatives, ensuring the democratic process is alive and well at the grassroots level. Elections are held to constitute new panchayats before the expiry of the current term, ensuring uninterrupted governance. This structure and timeline ensure regular democratic local governance. Representation and leadership form the backbone of any democratic institution. So how does it work in panchayats? In the spirit of inclusive governance, the Indian Constitution, under Schedule 11, mandates reservation of seats in panchayats for scheduled castes, scheduled tribes, and women. This provision ensures that these historically marginalized sections of society have a voice in local governance, thereby promoting social equity and justice. Now let's talk about leadership. The chairperson of the panchayat is an integral figure, steering the course of local governance. Their role is to ensure the smooth functioning of the panchayat and guide its actions towards the welfare of the community. But how is this leader chosen? The chairperson is either elected by the members of the panchayat or selected through direct elections by the villagers, depending on the regulations of the respective state. This ensures adequate representation of marginalized sections and clear leadership within the panchayat. What powers do panchayats hold, and who holds them accountable? These are two key questions that help us understand the significance of panchayats in India's rural governance. Panchayats, as per Schedule 11, are endowed with powers and responsibilities in various sectors. They are involved in agricultural development, executing land reforms, fostering animal husbandry, promoting rural development, and ensuring social justice. Not just that, panchayats are also tasked with preparing plans for economic development and social justice and implementing welfare schemes for their local communities. But what about their finances? Here's where the State Finance Commission steps in. It's constituted by the state government to review the financial standing of the panchayats and recommend the distribution of financial resources between the state and the panchayats. And to keep things transparent, provisions are in place for the audit of panchayats' accounts. This audit is conducted either by the state auditor or an authority appointed by the governor. Thus, panchayats have clearly defined powers and financial accountability. Elections are the lifeblood of democracy. How do they work in the context of panchayats? Let's dive in. The Election Commission of India, an autonomous constitutional body, oversees the electoral processes for panchayats. It ensures that elections are conducted in a free and fair manner, adhering to the principles of the Constitution and the laws set by the state legislature. Now, what about scheduled areas, you may ask? These are regions that have been recognized by the Constitution as requiring special protection due to the unique socio-economic conditions of their indigenous tribal population. The provisions of Schedule 11 are extended to these areas, with certain modifications and exceptions as specified in the 5th Schedule of the Constitution. This ensures that the benefits of local self-governance and decentralized power reach even the most marginalized sections of our society. This brings us to the end of our journey through Schedule 11, the backbone of local governance in rural India. Ever wondered who holds the reins of urban governance in India? In the heart of India's urban development and governance lies a powerful entity known as the municipality. These urban local bodies hold substantial authority and responsibility, all outlined in Schedule 13 of the Indian Constitution. This document empowers municipalities to efficiently administer and manage urban areas, and the provisions within it give them the autonomy to make influential decisions. From urban planning to the regulation of land use, from the creation of municipal corporations to the management of municipal finances, the reach of a municipality is vast and varied. As the primary taskmasters of urban regions, municipalities play a pivotal role in improving the quality of life for city dwellers, promoting sustainable development and ensuring public safety. With the authority to regulate markets, provide essential urban amenities, and even handle fire services, municipalities are an integral part of India's urban framework. Let's delve deeper into the key aspects of Schedule 22. At the heart of urban management lies planning and governance. Anchoring the urban landscape, municipalities shoulder the responsibility of urban planning. This includes town planning, meticulously crafting an urban layout that balances aesthetics, functionality, and sustainability. The regulation of land use is another crucial task that falls under their purview, ensuring the space is optimally utilized while minimizing the environmental impact. But their responsibilities don't end there. Municipalities are also the architects of economic and social development, fostering an environment that allows businesses to thrive and communities to flourish. Now, let's talk about governance. Municipalities aren't just planners, they're administrators too. They hold the authority to establish and oversee municipal corporations, municipalities, and Nagar Panchayats. Furthermore, they're responsible for the election and composition of these bodies, ensuring a democratic process within the urban expanse. So, municipalities play a pivotal role in shaping our cities. But here's a question. But how do these municipalities finance their operations? Municipalities have the power to levy taxes and manage assets, This might sound quite dry, but it's a crucial aspect of urban governance. Imagine, if you will, a city as a vast engine. It needs fuel to run, and that fuel comes in the form of taxes, fees, charges, tolls, and rents. These sources of revenue enable the municipality to provide essential services, develop infrastructure, and ensure the city's smooth operation. However, the responsibilities of a municipality don't end there. They also involve managing and regulating municipal properties and assets. This includes everything from office buildings and parks to vehicles and equipment. The municipality ensures these assets are maintained properly, utilized effectively, and when necessary, disposed of responsibly. So, when you see a city bus or walk in a city park, remember, it's the result of careful management of municipal finance and assets. But a city is more than just buildings and roads. It's a living, breathing entity, and municipalities ensure it keeps thriving. Municipalities also ensure the health and safety of urban residents. With the mantle of public health and sanitation services, these local bodies ensure the provision of clean drinking water, efficient sewerage, drainage, and effective waste management. This is a vital aspect of their role, as it directly impacts the well-being of millions of urban dwellers. But the responsibilities of municipalities don't end there. They also provide and maintain essential urban amenities. This includes the upkeep of roads, bridges, and street lighting, as well as the creation and care of public spaces like parks and playgrounds. These amenities, often taken for granted, form the backbone of urban life, making cities livable and vibrant. Furthermore, municipalities are also in charge of providing fire services. This ensures public safety in case of emergencies, further enhancing the security of urban areas. They are truly the guardians of the city. Yet, there's more to urban governance than meets the eye. Municipalities are the drivers of urban development. They take on the monumental task of transforming urban spaces, making them more livable and sustainable. One way they do this is through slum improvement initiatives. They work tirelessly to upgrade infrastructure, provide essential services, and improve living conditions in these densely populated areas. Additionally, municipalities shoulder the responsibility of providing housing for economically weaker sections of society. They ensure that everyone, regardless of their economic status, has access to safe and affordable housing. This is a crucial step towards achieving social equity in urban areas. But the work doesn't stop there. Municipalities also regulate land use and construction activities. They set and enforce building codes to ensure orderly growth and development. They decide where markets, slaughterhouses, and other trading activities can be located, striking a balance between economic activity and the well-being of the residents. In essence, Schedule 14 empowers municipalities to govern urban areas effectively. In a nutshell, Schedule 13 outlines the key powers of municipalities. From urban planning and governance to the management of finance and assets, these bodies play a pivotal role. They ensure public health, provide amenities, and maintain safety. They regulate markets, manage fire services, and promote urban development. Their authority extends to land use and construction, making them instrumental for orderly growth. So the next time you wonder about urban governance, remember the crucial role of municipalities outlined in Schedule 2.